Hey, welcome to our last asynchronous day. The quote unquote assignment today is for you to watch these, cases through the lecture. It shouldn't take too long. And technically speaking, all that I'm grading you on is that you went through the video. I don't know if you actually took notes, but it's highly advisable that you do as we head towards our Fifth and Sixth Amendment oral arguments next week. So, yesterday we started the Sixth Amendment by looking at the right to counsel, starting with the Scottsboro boys, going through Betts v. Brady, and then ending up with my hero, Clarence Earl Gideon, the stubborn, simple man who actually made it so that everybody can get a public defender. Well, today we're going to look first at influences on the jury, and then we're going to ultimately look at something called the confrontation clause. So again, every person that is accused has the right to an impartial jury of the state and district wherein the crime should have been committed. Okay, so at the end of the day, what we're not going to actually look at is the composition of the jury. Those are a little bit more complicated. We're going to look on the courtroom influence on the jury. Really fascinating case. So the case of Carey v. Musladin in California. So Matt Mizladin killed Tom Struder, but he said, listen, I did it, but I did it in self-defense. So again, no question of whether it actually happened, but the defense is that I had to defend myself. Now, actually, during the trial, not every single day of the 14-day trial, but most days, members of Struder's family sat in the spectator area wearing small but definitely noticeable 2x4-inch buttons with his picture on them. It was visible to everybody, the jury, the judge, anybody who was sitting on the witness stand. Once you were looking out at the spectators, you could see them. Musladin's attorney is like, no. You got to get these removed. They're going to prejudice the jury. They're going to make, them be sympathetic to Struder, not to me, because again, I did it in self-defense, but they're going to see the buttons. And the judge says, no, I don't actually think that they're anything more than just, grief-stricken spectators who are here to hopefully see, the person that killed Struder go to prison. Now, Musladin is convicted of first-degree murder. And not surprisingly, he appeals. And he says, listen, the wearing of those buttons was clearly prejudicial against me, and I believe it tainted the jury's decision. So the question for the Supreme Court ultimately was, were these buttons nothing more than a sign of normal grief from family members, or did they actually have an influence on the jury? Okay. Well, the Supreme Court ruled unanimously against Musladin. Okay, so they didn't buy the argument at all, but they sort of did it on a technicality, if you will. They're like, listen, there's no actual rule that says that this can't be done by private citizens. There are certain rules that say what the state, namely the prosecutor, can do. So they said basically, since there's no rule against it, the buttons are allowed. So a bit of a technicality. But the concurring opinions say even more. And again, it's important for us to look at those concurring opinions, hint, 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 because you may see a case very similar to this next week with the oral arguments. So let's look at those, okay? So yeah, we don't always look at concurring opinions, but when they're really relevant to next week, we certainly should. So remember, a concurring opinion is somebody who's on the side of the majority opinion, but comes at it from a different angle. So Justice Kennedy says, listen, there is no evidence in my mind that these buttons created any type of disruption. We can almost take ourselves back to Tinker v. Des Moines, material and substantial interference. But he says, you know what? There aren't any rules about what, private citizens can do, but maybe the court should have the authority. I have a typo in there. It says to prohibit. Just give the court that option. Okay. So he sort of says, you know what? It's totally allowed right now, but maybe the court should have the option to do this, in the moment, to be able to really make sure that there's no arguments about prejudicial behavior towards the jury. Now, Justice Souter had a different concurring opinion. He goes, you know what? The whole focus that we should have looked at as a court was whether these actions by the spectators were unreasonable or not. And he says, you know what? I don't think they were unreasonable. I don't think they made any sort of disruption. They just sat there with the buttons on, just like John and Mary Beth Tinker just were going to stand there with their armbands on. And it's interesting because, again, the reason that it's a nice linkage to Tinker is because Souter said, you know what, it wasn't really brought up in terms of a First Amendment argument, but perhaps we should have looked at it this way, or perhaps attorneys should have argued about this, because, like, isn't this not your First Amendment right to speech and expression, just to sort of sit there quietly with what would be known as symbolic speech, no words written or spoken, but just sitting there with a button. So again, keep these concurring opinions in mind as we head into next week. All right. Let's give you a chance to make sure you got this stuff written down. We're going to head into another part of the Sixth Amendment known as the Confrontation Clause. And it says, again, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. That means if somebody is going to say something about you and incriminate you, you have the option and the right to have them in court, basically to face you, but really your attorney, as your attorney, probes and investigates and tries to show that basically what they're saying is wrong so that you can go free. Okay. So I start here with a picture of 21 Jump Street, the original 21 Jump Street. That is Johnny Depp at a very young age, way back in the 80s. And again, it was like the other 21 Jump Street, the movie with, Channing Tatum and Jonah Hill, although not comedic, very dramatic. But just check out that late 80s fashion. Wow. All right. So this is an undercover cop case, and that's why I brought up 21 Jump Street. It's undercover cops. But in this case, back in the 60s, here in Illinois, an undercover police officer gave a fake name on the witness stand. So the trial is against Smith for selling drugs, and an undercover officer comes up, and then when asked his name, he ended up giving a fake name. And so the attorney basically says, like, hey, that's not your real name, James Jordan, is it? And the officer's like, yeah, that's actually not my name. And then the attorney asks, well, what's your real name? And then there's an objection, says objection. And the judge says, okay, you don't have to say your real name. And he's like, the attorney says, well, where do you live? And the other attorney says, objection. And the judge sustains it. And so in the end, the reason the judge did that was he believed that if this, quote, James Jordan had to give his real name and his real address, it would blow his cover as an undercover officer and put him potentially in danger. Okay, we can see how that makes sense. Okay. So after the conviction, Smith appealed the decision. He's like, listen, this is a violation of the Confrontation Clause. My accuser got to be there in court, but he didn't have to play his full role, okay, by not having to say his real name and where he lived. And in this case, the court ruled 8-1 for Smith, okay? So they're like, yes, Mr. Smith, we believe that there was a violation of the Confrontation Clause in your case. And so they said, if you don't say your name and you don't give your address, that's not a legitimate cross-examination. The defense team, again, who's assigned to defend the defendant in this case, who, if they lose, loses life, liberty, property, they say, the lawyer and the defendant can't truly know the person on the stand. And you say, well, why is it important to know the person on the stand? Well, it's not just what's on the stand. It's all of the information ahead of time that a defense team would go through. They would research who would be, speaking against the defendant. They'd find out if there's any possible bias against the defendant they could bring up. What's the record of testifying in other cases? Does that person have a criminal record? So it's not just like what's happening on the stand. It's all the work that would happen prior to. So again, you have to reveal your name, your address. You have to be honest up there on the stand about who you are, even if you are an undercover cop, like Officer Tommy Hansen was, played by Johnny Depp back in the 80s and 90s. Okay. So go on to the next two cases, which both involve children. Okay. So in this case in Maryland, there's an accusation of sexual abuse of a 6-year-old child by a daycare provider named Sandra Craig. All right. So what we have here is we have a young child who says, I was abused. Now, there were concerns like, do you bring the 6-year-old into court to testify against their daycare provider? Like, yes, you're supposed to have the right to confront, but is this going too far? So the judge says, okay, we're going to put the child in another room where the testimony can be viewed and the defendant and the defense team can object from the courtroom. So basically, the kid doesn't have to see all that's going on, but everybody can see the kid. Okay, so again, trying to create some buffer, some protection there. Well, Craig's convicted and appeals. And ultimately, the next sort of level up, the appellate court says, yeah, you know what? I agree with you. Like, you have to have the right to see and interact with your essentially your accuser, or else the confrontation clause is violated. So they reversed the decision. Well, then the state of Maryland then appealed to the Supreme Court, and they're like, you know what? We think what we did was totally fine, and we don't want Craig to get off. So Maryland appeals to SCOTUS, who have a narrow decision. They actually rule in Maryland's favor. They say doing the, closed circuit video feed from another room was constitutional. And the reason they say that, and I don't think it's terribly surprising, is they say, Maryland has an interest in protecting the physical and psychological well-being of the child. And that ultimately, in this case, outweighs the defendant's rights to face their accuser. It wasn't like you didn't know who your accuser was. You got to see what your accuser was saying. You got to object, but you didn't get to do it face to face. But you still had what we believe is a legitimate confrontation while protecting the child from having to do this against their daycare provider in open court. Okay. So last case is Ohio v. Clark, and involves an even younger kid. So a preschool teacher sees that a child in the care of the preschool has some bloodshot eyes. Looks like something's wrong with the eyes, and then it looks, and maybe there's like some whipping that has gone on, like whip marks, and then they look at the child, they lift up the child's shirt, and they see that there's just a bunch of what appears to be abuse marks. And they ask the child, and the child says it's D, who is her mom's boyfriend and actually also her pimp. Okay, so D was the pimp, and the mom is the prostitute. And he sent her out of town for, quote, work, and she left the 3-year-old and 18-month-old in his care. So he goes by D, but again, last name Clark, and that's the name of the case. And so the teacher testifies about this at the trial, but they don't bring the kid in. They don't put the kid on closed circuit video. They just basically say, we're going to use the words, of the kid through the teacher. And Clark says, no. Okay, I know I was convicted for child endangerment and domestic violence, but I never got to face my accuser, like in any way, shape, or form. Basically, this is all like hearsay. Like, the kid told the teacher, and now the teacher's up here, but that's not the way the confrontation clause works. That's way too indirect. So in this case, there was a unanimous decision in favor of Ohio. So again, 9-0 for Ohio and against Clark. And what they said was, listen, a teacher's role, that's what my role is, okay, as a mandated reporter of abuse. And again, if we hear anything about abuse, we have to mandate it. They said that made her able to testify as to what the child said, and the child doesn't need to take the stand. Now, it might be different if the child were older, different sort of circumstance, but here, due to the age of the child, we believe that the teacher was perfectly legitimate to sort of represent the child's words. Okay. So again, we talked about in the Carrie Misladen case about potentially influencing a jury so that it's not impartial, so that's, quote, partial or prejudiced with the buttons. And then we looked at 3 cases having to do with the confrontation clause in terms of having to say your name, give your actual real identification, and then 2 kids cases where they made exceptions to kids having to appear, confronting the defendant. All right, folks, hope you have a great day, and I will see you tomorrow.